Dobar dan. Good afternoon to everybody. Welcome back to our session. And first of all, before we start, I would like to thank the Institute for Social Sciences, especially to director, Dr. Goran Bašić, who is not just a director, but is also our colleague and friend, to organize this meeting. We are all aware that organizing such meetings is important because we can discuss the topics important not just for the scientists, but also for the politicians, and especially for, let us say, minorities in all sense. Today in the morning, we have heard a lot about nationalism, about populism, but this afternoon is dedicated to multiculturalism. Multiculturalism is, of course, a very, let us say, syntagma that describes a lot of things, and it has to be discussed very complex because it's not just one-sided. It's not the part of culture, language, sociology, demography, but it's important from a lot of aspects. We scientists, but a lot of times we use the syntagma multiculturalism, not knowing what in sense this is meaning. We have to ask, what is multiculturalism? What is beside this word? For whom is dedicated multiculturalism? How we can live multicultural life, how we can live. It's just a simple definition, or is a complex of, let us say, propositions, orders, way of life. Really, it's a much more, very difficult to live. It's easy to say, it's easy to make a definition, but it's very difficult to provide everything in the real life. So I will stop now with talking, but I am very glad that we have here really eminent and very expert on this topic, and we are going to hear about all aspects of multiculturalism. But I think that we are going to dedicate of national minorities in the policies of multiculturalism, which is in a way a little bit narrow topic of multiculturalism. Besides today in the afternoon, beside Dr. Bašić, Dr. David Smith, Dr. Tove Malloy, I think that she's going to be on Zoom, Dr. Andrea Udrea, and we are going also to listen to the fifth scientist, Dr. Patrick Simon, better, okay, from France, because due to some travel problems, he's not going to be in the area tomorrow, but he's going to have a lecture today. So I would like to ask first Dr. Goran Bašić to give his talk about national minorities in European policies of multiculturalism. The floor is yours, Goran.
Hvala, Sonja. I pošto smo već platili prevod, onda ću iskoristiti tu priliku da govorim na srpskom jeziku. Profesorka Vukanović nam je sada postavila visoke standarde u vezi sa multikulturalizmom i ja sam srećom izabrao temu o kojoj se malo govori direktno, ali koja je uvek napeta i koja je uvek prisutna kada se govori o organizaciji i upravljanju multikulturnim društvima. Reč je o odnosu monokulturalista, neko će to nazvati nacionalistima, ja ih ne zovem nacionalistima, i multikulturalista. I ona takođe ni u teoriji, ni u praksi nije nova, ali bih voleo da ponovim nekoliko detalja koji mogu biti važni baš sa aspekta monitoringa i u vezi sa svim ovim promenama ili obnavljanjima loših praksi koje se dešavaju oko nas. Razumevanje perspektiva monokulturalista i multikulturalista, kao i prevazilaženje teorija i praksi neprobojnih kulturnih granica, predstavljaju jedan od najsuptilnijih izazova i savremene socijalne misli i političke prakse. I podsjetit ću vas samo što su najčešće razlike između monokulturaliste ili nadzora monokulturalizma i multikulturalizma. U ideji monokulturalista je uvek monistička ideja da društvo treba tražiti u jednoj dominantnoj, organizovati u jednoj dominantnoj kulturi. Za razliku od njih, multikulturalisti, u stvari pluralistička ideja o očuvanju i poštovanju kulturne raznolikosti je u esenciji multikulturalne perspektive. Za monokulturaliste društvo bi trebalo da ima najpoželjnije jedinstvenu kulturu, obično baziranu na dominantnoj etničkoj, jezičkoj ili kulturnoj grupi, a za multikulturaliste važna je otvorenost društva prema više kulture i jezika, očuvanju različitosti i autonomije manjinskih grupa. Kod monokulturalista proces asimilacije je prirodan proces u kojima manjinske grupe poželjno je da usvoje dominantnu kulturu kako bi postali deo glavnog većinskog društva. Nasuprot njima inkluzije na njoj zasnovane politike koje poštuju ljudska prava i identitet različitih kulturnih grupa su svojstvene multikulturalistima. I najzad, ova četvrta red poređenja se odnosi na to da je za monokulturalizam važno očuvanje jedinstvene kulture, jer ona doprinosi stabilnosti i jedinstvu društva, a nasuprot tome multikulturalnosti vidi kulturnu raznolikost i kao resurs i bogatstvo koje doprinosi širem društvu i njegovoj održivoj organizaciji. Ove razlike su manje više jasne i negdje se tačno vidi gde su postavljene granice između mono i multikulturalista. S jedne strane je znači dominantna ideja o snažnoj nacionalnoj državi u kome su etnokulturalni identiteti građana uronjeni u opšte liberalne vrednosti, o jednakosti i slobodi za sve. S druge strane, multikulturalisti se zalažu za priznavanje i očuvanje etnokulturnih identiteta i kreiranje inkluzivnih politika koje eliminišu diskriminaciju po ličnom svojstvu pa i po nacionalnom. Ova dva glavna toka ideja konstituisale su u brojnim političkim teorijama nacionalizma i o njima je sjajno danas govorio, većini od njih je govorio Siniša. Međutim, iz tog izlaganja, i mislim da među nama tu nema spora, među svim tim teorijama se nalaze brojne varijacije, ti narcizmi malih razlika, koji su tačke sporove, ali i mesta na kojima je polugavna politička i pravna organizacija društvenog života moguće urediti na takav način da društveni odnos etičkih grupa funkcionišu. Kada kažem urediti, mislim da se eliminiše rizik od konflikta i potpune majorizacije, obezbede uslovi za opstanak manjinskih etnokulturnih nacionalnih zajednica, ali po pravilu ne ostvaruje se integracija ili još poželjniji model društvene zajednice, socijalna inkluzija ili interkulturalizam. I ako pažljivije budete čitali ovu monografiju koja je pripremljena o monitoring minority rights, vidjet ćete da su balkanska društva upravo tako. Sve je uređeno, sve je za multikulturaliste uređeno i za ljude koji žive multikulturalni nadzor po monokulturalnoj načinu. Sada kad govorimo o ovim teorijama, one su utemeljene u različitim izvorima. Najčešće one se određuju u etnosu i u kulturi i to su primordijalni ti sentimenti koji su korenjeni u ljudskoj prirodi. Druge vrste teorija, nacionalizam, tome isto danas govoreno, posmatraju kao pozitivan proces u određenim delovima sveta koje su bile pod kolonijalnom vlašću i koja sada utemeljuju nacionalni identitet. Takav identitet se može graditi oko jedne dominantne etničke zajednice ili oko više i tako dalje, ali u svakom slučaju tu postoji taj snažan opet monokulturalni nadzor koji organizuje društvo. Međutim, meni su u stvari najinteresantnije ove pozitivističke teorije, to su uglavnom se vezane za politikologe, koji nacionalizam posmatraju kao politički instrument za postizanje određenih ciljeva, uključujući stvaranje države, očuvanje teritorijalnog suvereniteta ili mobilizaciju političke podrške i koje su podložne instrumentalizaciji od strane političkih lidera kako bi postigli svoje ciljeve. Uz ovaj stav se u vezu dovodi populizam. I o tome je bilo reči, kao politička tehnika koja je po pravilu usmerena na narod, na vezu države i političkih ciljeve i etnosa, koja izaziva strastvene emocije, bes, strah, osjećanje da su za naš položaj krivi drugi i slične osjećanje. Međutim, ukoliko je nacionalizam ili taj monokulturalni nadzor može biti uzrok straha, a u prošlosti je izazivao patnje i sunovrate civilizacije do beznađa, otkud onda da su nacionalisti toliko popularni i uživaju podršku ljudi? Nastojeći da objasni neobjašnjivo, Mario Vargas Llosa ukazuje na to da su svi levi i desni nacionalistički pokreti u Južnoj Americi završili diktaturama. I citiram, nacionalizam je veoma rasprostranjena ideološka izopačenost, jer deluje na instinkte koji su duboko ukorenjeni u ljudska bića, poput straha od različitog i novog, straha i mržnje prema drugome, osobi koja se divi drugim bogovima, govori drugi jezik i neguje drugačije običaje. I zapravo, suviše je reći, ima instinkte u potpunoj suprotnosti sa civilizacijom. Zbog toga je nacionalizam naših dana samo reakcionarna, antiistorijska, rasistička ideologija, neprijatelj napretka demokratije i slobode. Ovo je veoma jedna radikalna kritika nacionalizma. Mnogi će nacionalizmu tražiti i pozitivne, međutim ja sam negde blizu ovoga mišljenja da nacionalizam čak i kada je dobar, kada se kaže patriotizam, ja ne mrzim nikoga, ja samo volim svoju domovinu, pa čak i onda možemo sumnjati u takav jedan monokulturalni nadzor. Sada što se tiče multikulturalnog nadzora, i to je ovo zašto nas se Sonja i prozvala, tu su društva koja teže ka uređenju kulturne raznolikosti i njihov predmet je pitanje kako upravljati i podržavati različite kulturne, etničke i jezičke zajednice unutar jednog društva. Najčešće raspravljamo o reformisanom liberalizmu i načinu na koji je on tretirao multikulturalizam i to je zaista jedna od svetlih tekovina ukupne liberalne teorije, verovatno pravedna dopuna teorija sa izvorišta liberalne misli, koji je usredsređen na priznavanje identiteta i na njiva zasnovanih prava manjinskih zajednica. Na taj način verovalo se da se ostvaruje društvena pravednost i ravnopravnost, da se odstranjuje, eliminiše diskriminacija, rasizam, etnocentrizam i tako dalje. On ima svoji podvarijanti kao što je kulturni multikulturalizam i u kome se kulturne vrednosti vrednuju same po sebi, nasuprot onoga gledišta koje smo malo pogledali da se samo jedna grupa, da se sve određuje u odnosu na nju. I opet ovde moj favorit je taj kritički multikulturalizam koji ima levu i desnu perspektivu i koji se u suštini bavi neravnotežom moći u društvu i kako ona utiče na priznavanje i vrednovanje različitih kultura. Ova perspektiva nastoji da proširi klasični multikulturalizam, stavljajući poseban naglasak na socijalne i političke dinamike koje oblikuju odnose između dominantnih i manjinskih grupa. I to je ona struja koja je bliska Paretovoj teoriji dijaloškog multikulturalizma. Ova interpretacija je veoma važna jer insistira na poznavanju sistema koji održavaju neravnotežu moći između dominantnih i marginalizovanih grupa. U okviru ovoga pristupa multikulturalizmu se razvio pozitivni duh koji je doprineo prepoznavanju i priznavanju prava manjinskim zajednicama, jer je insistirao na institucionalizaciji važnih društvenih odnosa između većine i manjine, među kojima too slowly, yeah? Yes. I try to be slowly. Među tim glavnim uporištima misli se na diskriminaciju, na dostupnost resursa, na suzbijanje siromaštva, na ekonomsku i kulturnu uskraćenost i slične fenomene koje nisu u esenciji multikulturalnog nadzora, ali jesu važne posljedice koje on treba da otkloni. Prednost kritičkog multikulturalizma je u tome što ima intersekcionalni karakter i otvoren je za druge socijalne teorije, marksizam, feminizam, za teorije rase. Najzad, njegova prednost je u tome što je otvoren za promišljanja o tome kako se različite dimenzije društvene nepravde prepliću s pitanjima kulturne raznolikosti i kako se mogu preduzeti koraci ka pravednijem društvu. U ova dva osnovna teorijska nadzora, mada ih ima više, ja sam ih prosto sistematizovao prema nekoj mom senzibilitetu i shvatanju ovog problema, trebalo bi tražiti linije na kojima se monokulturalisti i multikulturalisti mogu složiti. Najčešće monokulturalisti i kada su oslobođeni od uticaja etničkog nacionalizma će svoju poziciju braniti visokim troškovima u nacionalnim i međunarodnim fondovima za organizaciju, funkcionisanje i upravljanje multikulturalnih društava. S druge strane, multikulturalisti će ukazati na činjenicu da su konflikti i socijalno raslojavanje najskuplji u javnoj potrošnji i da su rizik za ukupan ekosistem. I kada su 2010. godine lideri nekoliko evropskih država u Evropskoj uniji proglasili smrt multikulturalizma i najavili razvoj politika na kojima će mišićavi liberalizam preuzeti stvar u svoje ruke, činilo se da je strah pred promjenama koje je donelo savremeno doba nadvladao vrednosti koje je u drugoj polovini 20. veka uspostavio reformisani liberalizam, u čijom centru su bili kulturni identiteti. Meni se čini da je tada načinjena krucijalna greška, jer se prenebeglo da štete koje su nanele loše politike multikulturalizma kojih je bilo, neće nestati ukoliko se u političkoj ravni poništi multietničnost kao tako. Sintagma smrt multikulturalizma će ostati upamćena kao jedna od najtamnijih strana u evropskoj istoriji. Obnova antisemitizma, jačanje islamofobije, rastućeg rasizma, na koji je nedavno uputila argumentovano i Agencija za fundamentalna prava, u izveštaju Being Black in the EU, zasnovan na iskustvu Evroafrikanaca, posledice su odustajanja i nedoslednosti u pre svega evropskim odgovorima izazove multikulturalizma. Demontiranje socijalne države i obnova liberalnog diskursa u kojemu triumviratu osnovnih vrednosti svojina ima primat nad jednakošću i slobodama, u temelju su podreli multikulturalni koncept. Sad, paradoks je veći ukoliko konstatujemo da su države implementirale većinu međunarodnih standarda zaštite prava nacionalnih manjina, ali da integracija, a kamoli interkulturalni dinamizam nisu postaknuti u meri u kojoj se očekivalo. Ono što bi trebali da imamo na umu, ljudima su njihove kulture, identiteti, jezici, vere, običaji, načini ishrane, oblačenja važni. Ljudi su različito obrazovani, imaju različite vrednostne nadzore i to je činjenica koja se mora uvažavati. Kada se to zanemari, problemi u multikulturnom društvima na relaciji većine i manjina se moraju pojaviti pre ili kasnije. Pre 3 decenije postojala je država, Dejan će odmah znati o čemu je reč, koja se zvala Jugoslavija i koja se suočila sa svim ovim izazovima, a u kojoj su prava nacionalnih i etničkih manjina bila snažno implementirana u društveni, kulturni i politički život. To se može pratiti u 2 ravni. Na nivou učešća predstavnika naroda Jugoslavije u odlučivanje o političkom i ekonomskim telima i drugo, o učešću nacionalnih manjina u jugoslovenskim državama u društvenom, kulturnom i političkom životu na saveznom i na republičkom nivou. Iako se u literaturi retko pominje taj model, on je bio veoma inspirativan i za kimličnu konstrukciju multikulturalnog građanstva i za savremene evropske politike multikulturalizma. Međutim, ne bi trebalo da zaboravimo zbog budućnosti ne samo da taj model multikulturalne politike nije mogao da se održi, nego je pod uticajem populizma, ksenofobije i nacionalizma bio pobuda za raspad države. Savremena Evropa ima to iskustvo i trebalo bi da na jugoslovenskoj lekciji projektuje politike za koje se i Evropska unija i Savet Evrope zalažu. Svoje jedinstvo Evropa ima samo kroz mnogostrukost i kroz razliku i očuvanje raznolikosti. Ono što čini ili bi moglo da čini njeno jedinstvo, koje je i samo pluralističko i protivurečno, jesu interakcije naroda, kultura, klasa i država. I kao takav interkulturalizam bi trebalo da predstavlja jedno od najrelevantnijih pitanja savremenih kulturnih politika i međunarodnih kulturno-političkih odnosa. Savet Evrope je 2006. godine kroz Belu knjigu o interkulturalnom dijalogu definisao dugoročnu politiku razvoja interkulturalnog dijaloga među evropskim zemljama, kao i između Evrope i susednih država. Tu je na jedan suptilan način označeno šta interkulturalni dijalog znači kao proces, šta bi trebalo da obuhvata i šta bi trebalo da se postigne. Posmatrajući posle 15 godina više sada od 17 godina od rasprave, od promocije te knjige, malo šta se u evropskim politikama od interkulturalnog dijaloga prepoznaje. Ranije je taj nadzor bio ekskluzivan za ovaj prostor na kome se danas nalazimo. Uglavnom se vezivao za Balkan. Sad mi se čini da Evropa sve više liči na Balkan. Da onaj nadzor koji smo želeli da mi ličimo na Evropu, da prihvatimo ta vrednost, čini mi se da postaje polako imanentan i na drugim prostorima. Ja ću nešto od ovoga preskočiti, svakako i samo ću pokušati da zaključim, da se u odnosu na pomenute napetosti unutar teorija i politika multikulturalizma, interkulturalni ideal je dalje nego što je to izgledalo 2010. godine. Međutim, premoć monokulturalista nad multikulturalistima ne bi trebalo da obeshrabri ove druge. Možda nema razloga za preterani optimizam, ali nema ni razloga da se odustane od kritičkog sagledavanja društvenih odnosa i posljedica politika koje u nacionalizmu nalaze osnov razvoja. Možete me kritikovati i opovrgavati, ali ja zaista ne verujem u dobar nacionalizam. Hvala vam.
Thank you very much, colleague Goran. You have concluded, I agree with you very much, and your comparison between monoculturalism and multiculturalism was very, very much important, and especially that you stress intercultural dialogue as a value. Many times we forgot what about the values of not multiculturalism, but of interculturalism, which is a big difference between these two concepts. Now we have to go on. I think that at the end we give the questions, or after, at the end of all the presentation, you will have the opportunity to ask our relators. So I would ask now to the second, our colleague, Dr. David Smith. He's coming from Glasgow, and he's from the University of Glasgow, and at the same time also member of the Advisory Committee of Council of Europe. The floor is yours.
Thank you very much. I hope you can hear me. First of all, thank you to the organizers for the conference, and thank you for inviting me. I decided to talk about a topic that will be familiar to, I think, everyone here, and that is the modality of diversity management known as non-territorial autonomy, or to use the favored term of the FCNM Advisory Committee, cultural autonomy. In my academic research over the past 15 to 20 years now, I hate to say, I've led 2 research projects on the practice of cultural autonomy in Central and Eastern and Southeastern Europe and the politics behind it. So the main focus in the projects was what I call the what, the why, the what and the why of cultural autonomy. What does the concept mean in practice in different contexts, and why was it adopted? And linked to this are the questions of by whom and for whom. So who decided on the adoption of cultural autonomy arrangements, and whose interests do these arrangements ultimately serve? And like very many people here today, more recently, I explored the theory and the practice of cultural autonomy as a member of the NTAN Cost Action, the European Non-Territorial Autonomy Network. And if you're not familiar with the network and its very many publications and outputs, I would encourage you to look at them, because they're a wonderful resource around this topic of non-territorial autonomy, but also diversity management more broadly. Now, cultural autonomy arrangements are today an established feature of numerous states that are parties to the Framework Convention, alongside the very many examples that can be found in Central and Eastern and Southeastern Europe, and which have, absorbed most of my attention. We can also mention the system of Sami councils in Norway, Sweden, and Finland. And the adoption of these arrangements mostly predates the adoption of the Framework Convention. In many cases in Central and Eastern and Southeastern Europe, the ground for these was laid already during the process of regime change in the late 1980s and early 1990s. And this was a time when international norms on minority protection were still a work in progress and therefore still something of a moving target. And for my own research purposes, it's been interesting to consider where these existing arrangements sit in relation to the Framework Convention and its concepts of minority protection. And, by extension, the extent to which they further the goals that are set out in the Convention and other documents produced by the Advisory Committee during the course of its existence. And these are the points I'll briefly reflect on in the presentation, but I'll also try to link my remarks to the central conference theme, which is, of course, multiculturalism. So if I go back to my 3 research questions. So first of all, what is cultural autonomy? If we take the second thematic commentary of the Advisory Committee, this defines cultural autonomy as an arrangement granted collectively to persons self-identifying as belonging to a particular national minority, regardless of where they live within a state or within a particular sub-region of a state. And the second thematic commentary, of course, deals with the effective participation of persons belonging to national minorities in cultural, social, and economic life, and in public affairs. And it's in this area of participation that cultural autonomy has been seen to have the greatest relevance if you look at the documentation. And the same thematic commentary states further that, among other things, cultural autonomy aims to delegate important competences to national minority organizations in the areas of minority culture, language, and education. Typically, this involves arrangements that are entrenched in public law, wherein communities of persons set up elected institutions of cultural self-government. And the examples I previously mentioned in Central and Southeastern Europe would all fit into that category. However, the term is used very widely. There's no clear single definition of cultural autonomy. And it's also applied to cases such as the Danish-German border region, where we see a network of private institutions and organizations recognized as fulfilling public functions. Now, if we turn to the question of why cultural autonomy, then we're obviously looking at a range of very different contexts of adoption and a range of different objectives that were in play when it came to setting these up. If we look at the establishment of the Sami councils, for instance, these are generally seen as arising out of sustained Sami political activism from below during the course of the 20th century. And their establishment reflected what Will Kimlicka describes as the rise of liberal multiculturalism or liberal pluralism within Western democracies during the later part of the 20th century. According to this liberal multicultural understanding, group differentiated rights such as autonomy are synonymous with justice, and they help to build fairer and more inclusive democratic societies. And so within this general paradigm, the devolution of power by a state is something to be carried out according to the formula that is most appropriate to the needs of a particular minority, be it territorial, non-territorial, or a combination of the two. And so against that background, cultural autonomy has been seen as a good fit for particular communities. And here the Sami have been cited as an example, that are today numerically small and live territorially dispersed, both within their traditional area of settlement, but also increasingly beyond their traditional area due to movement within the state. So that's one context, but in other cases, we can see that collective autonomy claims from below were more obviously securitized. They were viewed by majority political elites as a potential threat, either to the preservation or to the consolidation of an existing state. And according to this logic, cultural autonomy has often been portrayed as a generalized alternative to territorially based arrangements. There's a wonderful quote from the historian and theorist of nationalism, Aviel Rochval, and he claims that cultural autonomy was portrayed as, I quote, a golden midpoint offering minorities the option of substantive cultural self-determination without linking it to territorial autonomy with all the centrifugal tendencies the latter may awaken. So here we're looking at a more top-down, a more statist approach that seeks to reframe minority claims to autonomy as something cultural in essence, as opposed to being bound up with politics and with issues, particularly of territorial sovereignty. This thinking, I would say, was inherent in the original early 20th century conception of non-territorial autonomy that was devised by Karl Renner and Otto Bauer, their goal being to preserve the Habsburg state within its existing boundaries and to transform it internally from an empire into a democratic multinational federation. However, this same logic, I think, could be readily seen in Central and Eastern Europe and Southeastern Europe during and immediately after the regime change of the early 90s and the demise of Yugoslavia and the USSR as multinational states and the emergence of putatively national successor polities. At this time, it's clear that cultural autonomy was viewed to a significant extent through the prism of security and through the prism of ethnic conflict regulation. And so we saw various authors applying mostly pragmatic, but sometimes normative arguments, saying that it was necessary to decouple the link between ethnicity and territory, to quote one publication, a link that was seen to lie at the heart of the traditional nation-state model. As I noted earlier, though, from the standpoint of liberal multiculturalism as developed by the likes of Kimlicka, attempting to deterritorialize and implicitly depoliticize minority identities is seen not only as unrealistic, but also inappropriate. And the empirical reality, if we look around, also shows us that in many instances, cultural autonomy arrangements have functioned as a complement rather than an alternative to territorially based forms of decentralization. For instance, we find cases where you see a cultural autonomy arrangement going hand in hand with the implementation of Framework Convention Article 10 provisions on the use of minority languages in relation with the local administrative authorities. And applying the same argument, it's pretty clear that the issues at the heart of Sami autonomy claims in the Nordic countries are not limited to language, culture, and education. They also concern issues of land use and resource management within traditional areas of settlement. Furthermore, even where minority communities are small, they're highly dispersed, and they're mainly concerned with preserving a cultural identity. we should be wary of applying a one-size-fits-all approach based on public legal institutions. This might not be the most appropriate because unless a community is sufficiently mobilized, it has the resources and the organization necessary, it's difficult to make such a complex arrangement work. And so, in sum, again, paraphrasing Kimlicka, a liberal multiculturalist approach would not attempt to deterritorialize minority identities. Rather, where you see minority aspirations for autonomy, the best way is to embed them within a wider liberal democratic constitutional framework according to the most appropriate formula. And this approach, I think, is reflected in the Framework Convention and in the resources of the Advisory Committee, as the documents acknowledge both territorial and cultural autonomy arrangements as potential means for enhancing participation in cultural life and participation more broadly by national minorities. What's important to note, though, is that these documents do not provide for the right of persons belonging to national minorities to autonomy, whether territorial or cultural, and indeed nor should the implementation of the convention be taken to imply any recognition of collective rights as such. And this is consistent with a pragmatic approach to drafting and monitoring that has not sought to define national minority. And while it's given states a measure of discretion in terms of implementation, it's also sought to leave room for the broadest possible scope of application under Articles 3, 4, 6, and 12. And so the emphasis is on accommodating all forms of cultural diversity as a source and a factor of enrichment for society through an approach that is essentially grounded in individual human rights and fundamental freedoms. However, as I've said, many state parties already provide for cultural autonomy arrangements, and thus the Advisory Committee has examined their functioning and their impact as part of its monitoring. And here, if I go back to the second thematic commentary, it sets out several parameters which are deemed necessary for successful implementation, and these are listed under the section Effective Participation in Public Affairs. First, constitutional and legislative provisions should clearly specify the nature and scope of the autonomy system and the competences of the autonomous bodies. Secondly, the legal status of these bodies and their relations with other relevant state institutions, as well as their funding, should also be clarified in respective legislation. And here it should be stressed that the thematic commentary emphasizes the need for bodies involved in minority protection to be given adequate financial resources to carry out their mission. Thirdly, persons belonging to national minorities should be involved and their views duly taken into account when legislation on autonomy arrangements is being prepared or is being amended. And this goes to the, by whom question that I set in my earlier research projects. And perhaps, equally significant if we're talking about participation in public affairs, we've also got to consider the effectiveness of autonomy bodies' influence on decision-making processes once they have been set up. As I mentioned before, the thematic commentary refers to cultural autonomy arrangements as a means of delegating competences in the sphere of culture and education. First and foremost, I suppose this speaks to Article 5 of the Convention on protecting persons belonging to national minorities from assimilation against their will, and on promoting the conditions necessary for them to preserve the essential elements of their identity. It's also highly relevant for Article 14 on giving every person belonging to a minority the right to learn his or her minority language, and on providing adequate opportunities for being taught in the minority language or for receiving instruction in that language. At the same time, the explanatory report to the Framework Convention states that the rights under Article 5 do not preclude state parties from taking measures in pursuance of their general integration policy. Similarly, Article 14 states that the opportunities for being taught or receiving instruction in a minority language are without prejudice to the learning of or learning in the official state language. And so in this way, the convention underlines the importance of social cohesion and the goal of ensuring that cultural diversity becomes a source and a factor not of division, but of enrichment within a society. And here there's an obvious link to Article 4 on the need for a full and effective equality framework, and the provisions of Article 15 dealing with effective participation in socio-economic life. And this here, I'd like to reference the work by our host, Goran Basic, who has said, you know, where cultural autonomy arrangements are not introduced within the overarching framework of what he calls integrative multiculturality, there's a clear risk that in the case of certain minorities, they may simply reinforce pre-existing patterns of segregation and exclusion. And here I think it's notable too that the convention and its accompanying text speak not of multiculturalism but of interculturalism. In fact, the words multicultural and multiculturalism don't figure anywhere in the documentation as far as I am aware. And in this respect, Article 5 and Article 14 also need to be viewed in the context of Article 6 and Article 12, which emphasize the importance of intercultural dialogue as part of a whole society approach, and also Article 3 on free choice of individual identity, including recognition of multiple identities. This perspective as well, I think, is important with regard to respecting the internal diversity of minority communities when it comes to the governance of cultural autonomy arrangements. So, you know, for instance, preventing as far as possible abuses when setting up electoral systems for autonomous bodies, and ensuring that once they've been established, all sections of the relevant community are represented and can make their voices heard within them. And I recall, Daniela, the last time we spoke, you said that it was high time, you know, the next step in cultural autonomy research would probably be to go to everyday members of the communities in whose name these bodies operate and get their perspective. And I think, you know, I would echo that, because the work I did mainly dealt with, you know, elite actors, the people who are involved in running these communities, but it'd be very interesting to widen that to the perspective of the population as a whole. And, you know, I think without the kind of respect of internal diversity that I've mentioned, there's a danger that cultural autonomy bodies could end up replicating the same kind of centralizing logic of the nation state, which they're supposed to, you know, challenge in the first place. Yes, I mean, to put it another way, and this goes to the for whom question, from the standpoint of the Framework Convention, cultural autonomy arrangements should be about meeting the diverse needs of the persons belonging to the relevant minority the minority community. They shouldn't be a question of, you know, a way of regulating power relations between communities that are defined somehow in mono-ethnic groupist terms. And if we look around, then experience and evidence suggests that if cultural autonomy is adopted in a context where these intercultural parameters are present, it can indeed serve as a way of empowering minorities and by extension promoting what Kimlicka calls citizenization and overall cohesion within a society more broadly. However, again, I stress that the appropriateness of such arrangements will vary according to the minority in question, and as always, we should be wary of somehow prescribing uniform models, uniform solutions for diverse needs. Where these parameters aren't absent, there's a danger, I think, that cultural autonomy becomes consistent with top-down management of ethnically divided societies, in which devolution of symbolic cultural functions is understood as a means of maintaining ethno-political stability. And if we look at the recent literature, then I think it's possible to see an increasingly critical tone towards many of the arrangements that currently exist. This is certainly the case if we look at the literature comparing arrangements in Central and Eastern Europe and Southeastern Europe. And we see a range of criticisms here from, if I go back to the parameters, we see works pointing to ill-defined legal status, competences that are largely symbolic, influence that is very limited, and funding that is inadequate. But also increasingly called into question, and this goes back to my point about going to the people and seeing what they think, the internal representativeness and legitimacy of these institutions is often questioned. And here we see accounts of institutions being captured either by political parties or by other interest groups that use them to pursue their own narrow self-interest rather than using them in the interests of the community more broadly defined. And it's also possible to point to cases where autonomy arrangements become captured by external kin state actors and instrumentalized by them for their own, again, particular self-interested purposes. And the work I've done, the examples I've found suggest that this, as often as not, has a very negative impact on the minority community per se, but also on the overall integration of the society where they live. And I think, another thing, of course, is where you get these kind of external interventions. This contributes or can contribute to a growing securitization of diversity. And this, of course, just to conclude, is by far the biggest challenge. And here, again, I was struck by what you said this morning, Petra, that I think looking back over the history of cultural autonomy, it was something that emerged within the context of, minority rights as peace building. It was then adapted into a concept of minority rights as human rights, but now, of course, we're seeing the pendulum swing back away from minority rights as human rights towards minority rights as anti-peace. And, within that framework, then it's very hard to conceive of these kind of arrangements taking hold. And I'll stop there. Thank you very much.
Thank you very much for your very interesting presentation about practice of cultural autonomy and about arrangements from positive and also negative point of view. I think that here, there are going to be some questions regarding to your presentation. And now I would ask, it's closed, is on Zoom. The online colleague from European University, Flensburg and Roskilde University, a colleague, Dr. Tove Malloy. It's really, we are very sad that he couldn't participate and couldn't be with us, but it is important that the technology, which has changed a lot, also give us possibility to hear you and in a way to be also with us. Please, the floor is yours.
Let me first apologize to the organizers that I'm not able to join you in person today. I really apologize for not making it to Belgrade last night, But as the organizers will know, we had a severe snowstorm, and I was not even able to get out of my house for some time, so I didn't make it. But I'm very happy to follow on the presentation by David, because I think some of what the points I will make will speak to his last point on securitization and kin-state relations. So my paper will focus on the surge in bilateral counter-interventions in multilateral minority rights monitoring since 2008, basically. Some states that no longer restrict themselves to addressing minority issues, but instead bring to bear other non-legal matters that apparently warrant bilateral action. And such counter-interventions are usually directed at, sorry?
We have some problems with the...
Okay, can you hear me now? Okay, can you hear me? Yes, okay. So such counter-interventions are usually directed at neighboring states that are home to kin minorities. And most arguments relate to, of course, the rights of the kin minorities, often rights that the complaining state does not protect domestically. But some states also lodge claims based on old grievances, such as border disputes or perceived existential threats. One might argue that this is common in international relations. However, in multicultural monitoring and minority rights protection, this is not automatically allowed. Multicultural cooperation functions within agreed values and rules that aim to minimize bilateral action. And multilateral cooperation on minority rights monitoring is precisely a result of centuries of bilateral agreements that failed to protect minorities. So if multilateral policies, provisions, and procedures aimed at monitoring minority rights allow for bilateral interventions, there are guidelines as to how such might be manifested. If these rules are not respected, multilateral protection of minority rights may be jeopardized, and the legitimacy and the efficacy of the systems may erode. The main argument of this paper is that the ideals of the 1990s of elevating minority protection to the multilateral level in order to make sure that states respect it, have slowly been eroded by some states that no longer seem to respect the rules that they have committed to in terms of multilateral cooperation. So on the basis of this, I will make an overview of the approaches to monitoring by the Council of Europe and the European Union. And this will be confined, of course, to the advisory committee's monitoring on the basis of the Framework Convention, and the European Commission's monitoring of candidate countries in the latest enlargement processes. So the theoretical approach is liberal institutionalism, and the method is policy analysis. And it will be argued that members of the Council of Europe and the EU seem to have ignored the legacy of previous centuries, manipulating of minority issues in favor of state strategies vis-a-vis states where kin minorities reside. And by disrespecting the good intentions of monitoring procedures that have been jointly agreed to, member states endanger the aim of minority protection. So first, I would quickly ask why multilateralism in the 90s? How did we arrive at the conclusion that minority rights protection should be a multilateral matter? There is general consensus among contemporary scholars that the multilateral approach to minority protection, as we've known it for the last 30 years, is a result of almost 2 centuries of missed efforts to elevate minority protection to the level of interstate relations. With the Peace of Westphalia, of course, we got the first rules of minority protection, but it wasn't really until the Concert of Europe in the 19th century that we first saw an interstate approach to minority protection, most notably during the Congress of Berlin in 1878. However, treaties including minority clauses remained a bilateral matter until after World War I, of course. That's when the League of Nations took over from the Concert of Europe. It was clear that minority protection needed an umbrella of a multilateral framework. Unfortunately, the so-called minority treaties system of the League of Nations did not survive for long, as we all know. Europe was not ready yet for multilateralism and the values and ideals of multilateralism. The fact that the United Nations did not see a need initially to establish strong standards of minority protection is, of course, lamentable, knowing that the world was now much more ready for multilateralism, but apparently not for minority protection within multilateralism. This is, of course, the reason why the framework established in the 1990s was not only a Zeitenwende, but also a necessity. Thanks to the experts who insisted on pushing the UN to develop minority rights protection in the ICCPR, and you could say the lessons from the minority treaties, we had precedents for developing a multilateral framework that we are celebrating today in Belgrade. For many, the 1990s became the happy decade that finally cemented minority rights and minority protection into the international human rights framework and thus secured the oversight of the international society. Historians celebrated the fact that the international community had finally seen the writing on the wall. Minority protection must be guaranteed at the international level in order that states will truly respect minority rights. Legal scholars were perhaps a bit more skeptical because of the lack of judicial powers in the new framework. International relations scholars were also skeptical, mainly because of the way that states signed up to it or were forced to sign up to it. However, the reasons for why the new or democratizing states were seeking memberships of the European Union, of the European institutions, seems at the time in the 1990s. Past grievances took over. Did we begin to see bilateral counteractions? The legitimacy of European institutions and their human rights standards were later questioned for reasons often unrelated to international cooperation. So why is legitimate important? One scholar of international law and human rights argued back in 1992 that there could be a backlash. Benedict Kingsbury, the New Zealand legal scholar and now director of NYU Law, argued that coercing unwilling states to participate in norm setting and institution building, which are isolated from the political and ideological background of these countries, would be counterfactual and only lead to ineffective systems. His analysis was based on the then debate of the right of non-state groups to self-determination, in his case, indigenous peoples. But Kingsbury's premise is instructive also for understanding minority rights and minority rights protection. States will not respect norms and institutions that their leaders may consider not conducive for domestic purposes. To such leaders, lack of legitimacy means lack of authority. And this in turn invites those who otherwise have the necessary power, meaning the states, of course, to apply the norms, in fact, to disrespect the system. This is what he argued. And my argument for the purpose of this paper is that disaffected leaders may put multilateral monitoring of minority rights in jeopardy by launching counteractions based on domestic grievances. So let me explain bilateralism within multilateralism. First, what do we mean by these terms? First of all, John Ruggie, the renowned scholar of international politics from Harvard, discussed the two types of lateralisms also in 1992 in an article. Multilateralism, he argued, is an institutional form which coordinates relations among three or more states on the basis of generalized principles of conduct. That means principles which specify appropriate conduct for a class of actions without regard to the particularistic interest of the parties, meaning the states, or the strategic exigencies that may exist in many specific occurrences. So the specific and particularistics would be go in the background. Bilateralism, on the other hand, he argued, differentiates relations case by case based precisely on a priori particularistic grounds or situational situations. So his definition of multilateralism is also explained later by other scholars and in dictionaries, and basically rests on three principles: indivisibility of interest among participants, commitment to diffuse reciprocity, and I'll explain that in a moment, and a system of dispute settlement within the institution or the organization in order to enforce a particular mode of behavior and conduct. Diffuse reciprocity is a notion developed by Robert Keohane, a scholar of international relations from Princeton, who argues that the arrangement is expected by its members to yield a rough equivalence of benefits in the aggregate and over time. Bilateralism, in contrast, is premised on specific reciprocity, the simultaneous balancing of specific quid pro quos by each party with every other on all issues. I'll just jump a little in. For these reasons, Ruggie also argues that multilateralism is a highly demanding institutional form. However, no matter how threatened multilateralism is perceived in current geopolitics, the argument is that multilateralism provides stability in comparison to bilateralism. This is what the international community saw in the 1990s, of course, motivated by the conflicts and, of course, new partners appearing on the scene after the breakup of the Soviet Union and Yugoslavia. So I will move on to discussing then the actual cases. I will begin with the Council of Europe. I think most in the room there are probably aware of how it works with monitoring in the Council of Europe, that the Committee of Ministers has the final responsibility in the monitoring of the Framework Convention as per Article 26 of the instrument. The Committee of Ministers' country resolutions on monitoring are by and large based on the recommendations made by the Advisory Committee in its opinions. During the preparation of a resolution, The participating states and non-state parties have an opportunity to express views with regard to the situation in the state being monitored. This part of the process takes place in a rapporteur group called, it's a group on human rights, but it's usually called GRH. And this group engaged in general policy discussions relevant to all their activities, of course. However, they have an important role in drawing up the draft resolutions ready and make them ready for the Committee of Ministers so that they can basically sign onto it. So the aim of the rapporteur groups is to function as forums for information and exchange and identifying problems before the resolution reaches the Committee of Ministers. Usually the period from issue of a country opinion by the advisory committee to the adoption of a resolution, there is a period from 6 to 12 months. And there are people there in the room with you who know more about this than I do, actually. But in some cases, the process from opinion to resolution has taken several years. And this is what we've seen after 2008. And most of these cases are delayed due to kin minority issues. So I'm going to go through a few of the cases that have been most prominent, starting with what I would call the example of Georgia, Russia, which began in 2009 in the Council of Europe in the discussions of the rapporteur group and lasted until 2014. So here you see that there is definitely an extended period, more than expected. There were numerous meetings, of course, on the agenda of the rapporteur group regarding Georgia after 2009. Of course, the topic which upheld the process was the 2008 war in Georgia, and there were divergent views on this, definitely. But eventually, a resolution was adopted in June of 2014. And the next Georgia resolution only took 3 years, whereas the third resolution took 13 months. So here we see a typical example of how the process is expanded and it's not conducive for the effectiveness of the whole procedures. The next case is Latvia, Russia, started in 2009, also after the opinion of the advisory committee. Again, substantive issues on kin-state relations, grievances between the Russian Federation and Latvia upheld this. But eventually in 2011, the resolution was adopted. And the second resolution then only took 6 months. And this was due to some citizenship issues, which is legitimate. A third example is Lithuania, Poland, where it was back and forth. Started also in 2009 and lasted until 2012. In the case of Lithuania, the first resolution was finalized in 10 months, whereas the second resolution was held up for 4.5 years. In fact, the preparation of the second resolution was absent from the rapporteur group's agenda for the first 2 years. Nothing was happening. Of course, the issue was kin-state issues, particularly the Polish side was not happy with and satisfied with the legal protection of Polish minorities, language issues, name issues, etc., as well as certain census issues. But the third resolution then took 3 years to finalize, whereas the fourth took 12 months. So similar issues then went the other way and upheld the resolution on Poland. So whereas the first resolution was finalized in 12 months, the second one took 3 years. The last example from the Council of Europe is Ukraine, Russia. perhaps the most controversial resolution process to date, has been the second resolution on Ukraine. So whereas the first resolution took 12 months, the second one took 3 years. The rapporteur group had many meetings on this, including informal mediation and consultations. Eventually, the case was handed over to the Committee of Ministers, but without any resolution from the rapporteur group. This is very unusual. So interstate relations again dominated, of course, this process. The kin states issues were tabled by the Russian Federation regarding language use, also in the media. But in the contrast to the long one from 2009, the third and fourth resolution were finalized in short processes of approximately 12 months. I could mention that at that time, there was a motion in the Council of Europe to try to find a solution to this problem. In 2010, actually, already, the rapporteur group discussed a proposal made by the advisory committee, the Framework Convention Secretariat in the Council of Europe. And this was in cooperation with a Directorate of Monitoring, which exists also in the Council of Europe. And this was to give the rapporteur group an opt-out, rather than just pass on, we can't solve the problem type of thing. They should be allowed to have a so-called fallback position. That would require the Committee of Ministers basically to request the Secretariat to draw up a legal opinion on the repercussions of the failure of the Committee of Ministers to adopt a resolution within a convention control procedure. The proposal did not survive and has never been spoken about again, I think not at least publicly. So let me move now to the European Union, and I should try to be really quick here because many of you will know the issues that I'm talking about. And this is, of course, the minority rights protection in the enlargement. But basically, this, as you all know, started in 1993 because prior to that, there were no examinations, even in enlargement. The only exception perhaps would be Spain and Portugal, which joined in 1986. There were concerns about human rights for the first time in the history of the European Union, then the European community, mainly due to the history of authoritarianism in these two states, in these two African countries. But there was no explicit monitoring of human rights. So it was basically just a concern. And this again then changed with the adoption in 1986 of the Single Market Act, which for the first time referred to human rights in what was to become the European Union. Enlargement conditionality, as many of you will know, it started with Copenhagen, 3 criteria of which minority rights were in the third. Excuse me. In the following years, the policy was developed and the system progressed with these reports that we're all familiar with. This was, excuse me, in preparation for the Big Bang enlargement in 2004 to 2007. And it was further developed then with the Thessaloniki European Council, also in 2003. In terms of multilateralism, the meeting in Copenhagen in 1993 was guided by the clear consensus that the criteria would be applied evenly on all applicant states. We know that this didn't happen in reality. The Baltic states did not fully comply with the third criterion, and Cyprus entered without no guarantee of the application of the rule of law in all of its territory. In 2006, the unity of conditionality, if you will, policy was further diluted. This happened and would have a considerable impact on the monitoring. Basically, the power of deciding which countries to invite to begin negotiations was moved from the European Commission to the Council of the EU and the European Council, of course. So before the EU, the Council of the EU had pretty much rubber stamped the Commission's recommendations. After 2006, negotiations would not start unless all member states had agreed unanimously in the Council of the EU. Experts have called this the fourth Copenhagen criteria and explained that there had been a sense among member states that the fourth and fifth enlargement negotiation process had not delivered on conditionality as hoped, and the process needed to be more rigorous. Specifically, there was concern that candidate countries were ill-prepared and public disenchantment was emerging. Essentially, the aim was to give the EU and the individual member states more control. The eminent EU scholar Christoph Hillian has called this an emergency brake. Originally, officially, of course, it was called an enhancement of the enlargement policy, enhancement. But in reality, it led to bilateralism, usually involving a member state on the one side and an applicant state on the other. So for the people in the room there, I'm not going to repeat. I have the cases of Croatia, Slovenia, which lasted from 2009 to 2011. Border issues, I'll jump to the next one. North Macedonia, first with Greece and then with Bulgaria. You're all very familiar with the issues. We're talking about something that started in 2004 and ended in 2022 and basically lasted 18 years. And then the more contemporary case, if you will, well, sorry, they're all contemporary, but the one that we are now watching in this and next week is Ukraine-Hungary, which started, of course, with Ukraine's application in 2022, and which next week should be given the go-ahead for negotiations. But as you are aware, Hungary is trying to stall this, and there is evidence that Hungary has used bilateralism before, also in the framework of NATO, which I'm not discussing here, but for those who don't know, basically, Hungary has several times interrupted Ukraine's participation as an observer in NATO meetings and basically refused Ukrainian officials to come to Brussels and participate. So as I said, the Copenhagen criteria were meant to be applied evenly. The EU would represent a united front with regard to conditionality, meaning the same conditions for all member states. However, this multilateral aim has long been shattered by allowing bilateral action in the enlargement process. So quickly, it's not new that minority issues are instrumentalized. We heard this in the previous panel also. We've seen it again and again in European history, but doing it through multilateral action in multilateral settings goes against the tenets and values of multilateral cooperation. And the whole idea of minority protection through multilateral frameworks was and is to avoid instrumentalization and bilateral action. So one might ask, why do states sign up for membership of international organizations and their norms if they do not intend to cooperate and find common solutions? Here I will draw on the renowned German-American scholar and professor at NYU, Professor Frank, In his 1990 book, The Power of Legitimacy Among Nations, he argued that states in multilateral cooperation are like communities that are drawn towards cooperation because they bring part of the community, the community will validate the existence. In this case, he means the existence and recognition of the state as a sovereign entity. But this seemingly voluntary cooperation pulls states into an ongoing relationship of compliance that legitimizes statehood. This is what he's saying. And they do this by agreeing to certain rules. Obligations are put on states as part of a reciprocal deal that guarantees the state legitimacy, even if their leaders do not fully agree to the rules and the multilateral community. The agreement to cooperate thus comes with a price, which is to compromise on rules, but not necessarily with an act of consent. Yes, we believe in the rules. You don't hear state leaders say that. The obligation to comply is associated rather than concurred. And according to Frank, the only way to avoid obligations is by leaving the community, thus risking, he says, the high price of maybe losing statehood or losing respect. I would say it's more like losing respect, because of course, in reality, there are nuances to this compliance obligations argument that he's putting. We've seen in the last 20, 30 years, states come and go in international organizations. And of course, the most well-known we could say is Brexit, the Great Britain basically leaving the EU. And they have not lost their statehood. So, however, in most cases, states remain within the multilateral order and find odd ways to balance the compliance obligations equilibrium. Rather than leaving the system, states will try to influence the multilateral process in their favor on matters close to their political and ideological concerns. This is potentially devastating for the efficacy of multilateral cooperation, as it may paralyze the processes and thus start the downward spiral that erodes trust and legitimacy. It seems clear to me that this method is being used in minority rights, minority protection, monitoring process. To conclude, and I'm sorry, I'm running over time here, I think bilateral action in multilateral minority rights monitoring can jeopardize both the legitimacy and the efficacy of such systems. Legitimacy is at risk when the tenets and the values of an international agreement are overtly or covertly disrespected. Efficacy will decline when processes are laden with obstacles not authorized by the procedures of an agreement. The aim of multilateral monitoring is precisely to avoid that interstate disputes and kin minority issues escalate into conflicts. We have the experience from the 19th and 20th century that interstate relations, they only give rise to broken promises. This is not to argue, of course, that bilateral action in multilateral cooperation should be avoided. And there's room for it, we know this. It's merely a warning that when European policymakers decided to anchor minority rights protection into multilateral level after the end of the Cold War and with the breakup of the big empire states, they expected that multilateral cooperation would contribute to peace and security. If states follow the rules and guidelines set for such multilateral cooperation, including constructive dialogue rather than stalling methods, interstate tension can be addressed before they become violent conflicts. Thank you for your patience. I'm sorry if I have run over time. Thank you.